for us, and the
Thank you very much. As I was saying, we have two important issues to discuss today. And where is the cover sheet?
We're going to open up with a word of prayer from the doctor on the committee, Dr. Senator Watson. You mic 16? Yes. All right.
Thank you, Mr. Chairman. Let's bow our heads. Dear Lord, thank you for looking over us in these days behind us and days ahead. Continue to guide us and let us do your work, and continue to look over us as we do our travels and our business. And in Christ's name I pray. Amen.
Amen. Thank you for doing that. As always, if you want to be heard on the bill, please come up here and sign up. The sheets are still out. Christian's going to bring me those sheets. Hopefully this hearing will be a little bit less eventful than the last one, and a little bit shorter than the last one. But we will start with Senate Bill 335. Senator Alberts, you want to come up? You want to introduce Ms. Treadway as well, who's going to be joining you?
Yes, Mr. Chairman.
You're on now.
Thank you so much, Mr. Chairman and members of the committee. I'm honored to be joined by our Cherokee County District Attorney, Ms. Susan Treadaway. She was named the District Attorney this summer by Governor Kemp when her predecessor joined the court. So we're excited to see two superstars in the legal world who have been serving our state for many years continue to thrive. And you may know Ms. Treadaway. Her district attorney work and prior work has helped on some of the things you and I have worked on, from organized retail crime to ending human trafficking, as well as significant work going after criminal street gangs, which we know are a serious problem. But today we're bringing a different bill to you that D.A. Treadaway mentioned to me was a concern and a specific issue that she had dealt with. And in this bill, which I will very quickly introduce because it is a small bill by the lines and the strikeout and additions, but it is enormous to the people affected. And I'll begin by saying this bill, named the Safeguarding Adopted Children from Sexual Violence Act, is that 99.9999% of all adoptive parents are simply heroes who have taken a child who's needed a home and welcomed them and made them a part of their family and given them wonderful lives. And I know this body especially has worked to increase adoptions in this state, and I know will continue to do so. However, on the unfortunate rare occasion that someone does do something wrong, we want to make sure they are fully accountable to the law. And in this case, this bill, very simply, as you can see on Section 2, beginning on line 13, adds to not by just blood, but by adoption that would implement the offense of the incest laws. And then you will see that again on line 17 underlined, where it goes from blood, half-blood, or by virtue of adoption. And that continues down on line 18, on line 20, and then again on line 22. So if it's acceptable to you, Mr. Chairman, I would ask District Attorney Treadaway to give a little more context as this bill was brought forward by her and her office.
That'd be great. Thank you, Senator Albers and Ms. Treadaway. Thank you for your work on this. Thank you for coming down today and joining us. I'll let you take it from here.
Well, first, I'd like to thank you all for allowing me to be here. It is a privilege and an honor to appear before you on this very important issue, and thank you to Senator Albers for carrying this legislation, which is much needed. To give a little bit of background, it makes me very sad to be here to tell you that this is necessary, because obviously I'm here because there are in fact incidents of incest occurring with adopted family members that make it necessary for this legislation to change. What this will do in looking at the sex crimes context, we currently, and I know you're all very familiar with child molestation, the aggravated child molestation, statutory rape, all of those crimes that address those who are not at the age of consent, which is 16 in the state of Georgia. Primarily what we have seen and what we are focused on here, although there are other cases, unfortunately, where it's applicable, is those children who have been adopted into families who are ages 16, 17, and 18 who are being victimized by adopted family members, whether that would be parents, grandparents, aunts and uncles, and as it is outlined here with the changes that Senator Albers has presented to you. And I would also point out, just looking at in a different context of an adult victim, I have a case currently pending in my office where it is a biological daughter who is an adult, and under the same circumstances, if this were an adoptive daughter, I would have nothing that I could prosecute the father for. And why this is important in consideration of that particular fact scenario, that woman now, who was a child at one time, was the victim of sexual abuse by the father, who never disclosed. And by the time she disclosed, the statute of limitations had passed. By that point, she had been groomed and had been abused for so many years that she really didn't know what was right or wrong in the context of a relationship with her father. So if we look at it in it being an adoptive situation, again, I would have no crime to prosecute. So it is necessary for children who are 16, 17, 18, and as well as adults well into adulthood.
All right. Do we have any questions from the committee for either Senator Albers or Ms. Treadaway? And Senator Setzler.
Thank you, Mr. Chairman. DA, thanks for being here. Senator, I'm just trying to understand the way the law operates. So, and this is just, I'm not asking questions I know the answer to. These are questions I really don't know the answer to. So what is what's the framework for incest between adults and versus, I mean, I'm trying to unpack all this. Does the statute of limitations different if there's a incest case because it's considered sort of never ending because the relationship stays in place? I mean, help us understand the fact pattern. If you've got someone that you find out that's 24 and had been incestuously violated when they were 16 or whatever, how does that different with this than it would be otherwise?
So I would have to say that it depends on the factual scenario, and I know that's not the clearest answer, but the law has changed so much over the years that the statute of limitations would be different, all depending upon the age of the individual, when they reach the age of majority, and when that act would have occurred. So it could vary, and that's another reason why this is important, because it's not something where historically you would look at a felony offense and you would say, well, the statute of limitations has always been 4 years on felonies generally. There are a couple of offenses that are not sexual in nature, but with sex crimes particularly, you really sometimes have to get a pad and paper and literally count the days that the person has been alive and look at the statute and look at the year or the date that it happened and figure out exactly what statute of limitations would apply. And in this particular scenario that I just mentioned, the woman is well into adulthood, so the statute would have well run by the time any of this would have been disclosed.
Now, when somebody, and I'm just trying to understand, I mean, this body's going to act on this. I just want to make sure we know exactly what we're doing. So, how does it normally work then? So, does the statute of limitation running stop at age 18 and just sort of freeze in time? I mean, what is the, and is there any, will this carry forward past the age of majority? So say there was a 20-year-old person that was adopted at birth, for example, and they, or adopted at age 10, either way, I guess it shouldn't matter. And then at age, 20 starts a sexual relationship with their adoptive parent. What's the status of the law today with respect to incest between adults? Is that still a crime? And is that perpetuated here? Just trying to understand what we're doing.
Yes, it is a crime. But I think looking at it between adults, you would have to first say, looking at it from my perspective, how would it come to be that I would even know that two consenting, if it were consenting, how would I even come to know as a law enforcement agency or one of the agencies that I work with that this was occurring? And so I think looking at it from the adult perspective, there's usually going to be a history of some type of abuse that happened to one of the parties at a younger age that would bring that forward to law enforcement. Typically, in the scenario as I just described, it would be a daughter who was abused by some family member growing up as a child, that the statute of limitations would have passed by the time that the conduct was disclosed. Then it would be up to us as district attorneys to take each incident, each fact, each case on its facts, and determine with our discretion whether or not there is enough to proceed. So let's say there was the example of two consenting adults who didn't want law enforcement to know or didn't have a problem with it. We don't have cameras in bedrooms, so we would likely never know that was occurring unless they procreated and it was, we found out through some other way that sexual contact had occurred. So in dealing with it from a law enforcement perspective, there's almost always going to be some catalyst that causes that conduct to come to light such that an investigation would even be necessary.
Thanks. Yes, sir. Senator Hatchett? Senator Hodges?
Yeah, I would just.
Your mic 12?
I am, yep. Thank you, Mr. Chairman. I noticed the definitions here that we're changing are similar to the definitions and that you see in the marriage statute. Are you aware?
I don't have that in front of me.
So what classifies as legal marriage in the state of Georgia, they're almost identical to this. If we were to change these, and there are situations where people who have gotten married, and I don't know if this is something that's out there, but through adoption, adopting or marrying their cousin that's adopted or something like that, how would this affect that if they're already married?
I would say If they're, and you're talking about adults who are
Yes.
married, and so there I would say, again, one of those parties would have to come forward to law enforcement and say, I would like for you to investigate this as a criminal case. And we do, when the victim is a child, obviously, we have to step in and say the law prohibits this conduct, and whether the child may have some type of feelings, and we're talking about a child being 15, 16, 17 who can voice that they don't want the person to get in trouble. It's a little bit different when you're looking at two adults who are married. There would have to be somebody who would come forward and say, I believe that there is a crime to be prosecuted here. I would say that I can't imagine, even if the law, looking at the definitions, even if somehow that would fit, I cannot think of any scenario where a law enforcement agency would take a charge of that nature and where a prosecutor would pursue such a prosecution.
Okay, and one more question. Is there a reason why cousins are excluded? Or is that just something we've not explored? Like first cousins, is that an issue you run into?
I have not seen that particular myself. I have
Okay.
not seen that. I can tell you that what we typically see is going to be adoptive parents, or unfortunately grandparents sometimes. And I'm sorry, I have examples in my head floating through with that. But looking specifically from my experience of 20 years, I have not had a case with cousins.
Okay.
Any other questions from the committee? Senator Hodges?
Just simply, all this does is add an adoptive relationship to these laws, right?
Exactly.
That's it, period.
Yes.
Okay. That's what I thought. I'll be glad to.
I have one more question, but otherwise a motion might be appropriate.
Okay, all right, good.
Senator Setzler.
Yeah, thank you, Mr. Chairman. I'm just reading through this. So as the current statute's framed, stepchildren are prohibited from having stepchildren and their step-parent, father or mother, are prohibited. That's considered incest under our current statute. Step relationships don't extend to siblings, though, or aunts and uncles. Is that correct in our current statute?
Yes, that is my reading of it.
And I just asked the question, 'cause I'm not trying to, we'll make sure we understand what we're doing. I'm not trying to say we should normalize this or say anything's okay. Something not being illegal is not that we're ratifying. I just want to make sure, the interest in this dating from sort of antiquity is this idea of the aside from the really bad social conditions it creates, it's just the whole idea of is there medical issues with people marrying their siblings and so forth. But that doesn't apply, that does not extend to step siblings today. So one could today marry a step cousin or a sibling, but it doesn't, can one do that legally today?
So looking, so if you're looking at the incest statute, looking at siblings of the whole blood or the half blood, if they are related by marriage, which is one of the parents is, if there is a child born.
By marriage, yeah.
Right.
Yes.
No.
Okay. So there's, just want to make sure we're not, because there's sometimes things that are not written in the language of the bill, the existing statute, that we're not familiar with. So, Mr. Chairman, I'm comfortable with this. Thank you.
Any further questions from the committee? No one has signed up to speak on the bill. Senator Hodges, do you have a motion?
Yes, Mr. Chairman, I move do pass, please.
And that's LC 491599. We have a second from Senator Calzert. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous.
Thank
Thank
you,
you.
Mr. Chairman. Thank you, committee members. Appreciate it.
Thank you all.
Thank you. All right, Senator Robertson, I know you're dancing between two committees, so if you represent him, let him get out of the way quickly, hopefully, and then I'll call you up. We have SB 332, working off LC 481010. Is that what you have?
Yes, sir, Mr.
All
Chairman.
right, the floor is yours.
Mr. Chairman, I think everybody on the committee is familiar with this legislation from last year as it became known as SB 92. And through the process of getting SB 92 initiated, it was determined after initial lawsuit filed by 5 district attorneys that the courts reviewed, and I'm happy to speak to any part of the court order that was issued, to where the courts push back on all challenges related to SB 92. And so as it continued on, the final step was to have the rules approved. And I think everybody involved in this knows that last year there was a lot of hard work done on both sides of the Capitol on this. And a lot of agreement, not a ton of disagreement, but some things that, nuanced things that concerned us. And the Supreme Court gave us guidance, and I also have that order if anybody would like for me to articulate their exact language. It was not harsh. It was just attempting to understand what exactly their role was in this legislation. And I must say that after reading their order, I tend to agree with them. I mean, they're only, Supreme Court justices, so I think they deserve a little bit of appreciation. But after doing all of that, all we are doing here is, if you look at line 14, we are striking the area where it says, provided, however, that such standards and rules shall be effective only upon review and adoption by the Supreme Court. And that is being removed from the previous legislation, and thereby the rules will be established and enforced by the members of the commission. And it will continue doing the exact same thing it has been intended to do. And reading the order from the Superior Court judge, it does not see those responsibilities as interfering with the job of prosecutors, district attorneys, and solicitor generals here in the state of Georgia. And I would be happy to answer any questions concerning Senate Bill 332.
Thank you, Senator Robertson. Just a little cleanup, Bill. We have a question from Senator Jones, or is it Senator Parent? Senator Parent.
Thank you, Senator. Can you tell me why the Supreme Court declined to take action as per specified in 92?
Yes, ma'am. If you'll give me just 1 second. Just came out of SLOGO and
A lot going on down here already, I understand.
I think it comes down to that normal question that seems to be somewhat of a tongue-in-cheek discussion between prosecutors and the Supreme Court and the role of prosecutors. It says the question then ultimately becomes one of the nature of the power that district attorneys exercise. If district attorneys exercise judicial power, our regulation of the exercise of that power may well be within our inherent power as the head of the judicial branch. But if district attorneys exercise only executive power, our regulation of that my glasses are fogging up from outside. Regulation of the executive of that power would likely be beyond the scope of our judicial power. So I think it comes back to that same question. I do recall it being asked in appropriations the other day, where does the district attorney's office fall? Do they fall under the executive branch or the judicial branch? And it says, as the commission rightly acknowledges in its helpful letter brief, our case law has not previously answered this question. So I think their discomfort in taking on this responsibility is we still have the unanswered question, is the district attorney part of the executive branch or part of the judicial branch?
Thank you. Is it the case that they probably will have to, the Supreme Court will probably have to grapple with that question, and depending on their answer, the underlying bill would potentially be struck down for being unconstitutional?
Senator, I think that is applicable to all legislation.
Well,
They're-
but
they're-
they've already kind of, right, been.
Well, no, I think what they're saying is until that question is answered, and, you know, and who answers that question? Is it this body here? Do we make the determination that a district attorney, I mean, they're in our Constitution. I guess a constitutional amendment could answer that question. So, and,
We could.
and, you know, my entire life has been managed by case law. And nobody loves being a part of it, but it's a necessary thing to have to go out there and do it. So I think what I read, and again, this committee's filled with attorneys a whole lot smarter than this deputy sheriff, but I think the way they wrote it is, and if you read the order from the Superior Court judge when the law was initially challenged, really the only question about any of this is that one question. Where does the prosecutor's office rest, the district attorney's office rest?
Would you agree that's a pretty big question as it regards to eventually assessing the constitutionality of SB 92?
I would have thought so, but it seems like I have discovered through this process that question's been ping-ponged around for a long time.
I hear you.
Yes, ma'am.
One final question. What are we losing here in just removing that, the review by the Supreme Court? I mean, there was a reason that was put in the legislation. Can you speak to that a little bit?
And I think I don't think we're really losing anything. I think we're actually gaining a better, smoother system. And also, I think what the prosecutors are gaining is an opportunity that if something were to happen and they were to want to challenge it on constitutional grounds, that they have now a non-biased, non-involved party, i.e. the Georgia Supreme Court, to answer those questions.
Thank you, Senator.
Yes, ma'am. Thank you.
Any further questions from the committee? Seeing none, no one is signed to speak on the bill. What's the pleasure of the committee? Motion to pass by Senator Hatchett. Do we have a second? Second by Senator Kennedy. And Senator Robertson, Legislative Council has pointed out one amendment that I think we should consider at this time. In the title of the bill, we don't have some language that we need as far as that would give reference to what's in the bill itself. The suggestion was on line 3, all the way to the end after privileged nature, between nature and 2.
Yes, sir.
We would insert so as to remove provision for review and adoption by the Supreme Court, semicolon. Does everybody understand the proposed amendment? Does somebody want to offer that amendment?
Could you read it again?
It would be on the line 3 between nature and 2 at the end. It would say so as to remove provision for review and adoption by the Supreme Court, semicolon. We have a motion by Senator Setzler. Do we have a second? Second by Senator Kennedy. All those in favor of the amendment say aye. Aye. It appears to be unanimous. Now we're back to the underlying motion to pass as amended. All those in favor of the motion, please raise your hand. Count 6. All opposed? I count 3. The motion carries.
Senator Parrott, I thought I had.
Thank you.
I'm wily like that.
You know, that's my
It
first
was,
name.
yeah, Senator Jones and Senator Ratt, right. For clarification from the administrative assistant, will the noes please raise your hand again? Yeah, Senator Ratt, okay, make sure we have the right count. Thank you. All right, thank you.
Mr. Chairman.
Last bill on the agenda, Representative Silcox, House Bill 500. Come on up. This is a bill that we had last year that moved out of this committee. I'm sure everyone remembers the discussion. But I think if you could, it's a bill that didn't go to the floor. I think it went through rules, but was never called for a vote. So it's back before us again. But please just remind us, I know it's a short bill,
Sure.
but please go through, remind us what the bill does, and we'll go through questions.
Sure. Thank you, Mr. Chairman. We are on LC 480852.
Thank you.
And this bill we did go through last year, but it really is just creating a new crime that anyone by means of fire or explosives that knowingly causes, encourages, or procures another to set fire to a law enforcement vehicle would be guilty of the new crime of arson of a law enforcement vehicle. Accordingly, the crime would be punishable by a fine of $100,000 and/or 5 to 20. There's no mandatory minimum. And it is interesting, since we discussed this last, I had the privilege of speaking with Mr. Peter Amon at the Buckhead Coalition Luncheon today, and of course he is running the APD for the city of Atlanta, and was able to tell me that the total property damage to date, including dozens of police vehicles as well as construction vehicles and other property, that the damage there has exceeded $100 million. So I do think that this is needed, because I do think we need to send a message to folks that come from out of state that that Georgia's not going to tolerate this behavior.
All right. Thank you, Madam Chair. Any questions for the author? Senator Cowsert.
Thank you, Mr. Chairman. I'm just curious, that amount of that fine seems so exorbitant. Are there any other criminal laws in Georgia with that high of a fine?
You know, I think that the amount, Senator Cowsert, is really significant, because I've spoken at length with Chief DeSimone in Sandy Springs about this bill, and he says that most new police vehicles, if they're fully loaded with their specialized equipment, cost approximately $100,000. So I think this is the right amount for this bill.
I've just seen other criminal statutes where there would be restitution would
Sure.
be one of the potential penalties that would be commensurate with what the value was, and I just wondered if that was.
Yeah, I did my homework on that.
All right.
Thank you.
Thank you.
Any other questions for Chairman Silcox? Senator Setzler.
Thank you, Mr. Chairman. I'm Representative Silcox, appreciate you being here with us. I think this is a problem that needs to be addressed. I think 5 to 20 is appropriate for someone who does this. My concern is, I'm just unpacking this, and this is just for sake of context. We look at our criminal attempt or criminal solicitation statutes. For a felony, you're normally talking a 1 to 5 felony if someone encourages, counsels, even the conspiracy to commit a felony. I mean, we're not just talking about the actor or those that aid and abet in the furtherance of the act. It's our criminal solicitation statute would normally be a 1 to 5 felony for someone who counsels or encourages, advises. Again, we're not talking about good behavior, but if there were a circumstance where somebody were, in a crowd, they see someone who's about to burn a police car, and they say, "Yeah, burn!" If there was a sort of a mob scene that set in essence, what we're doing by this, just to make sure we're clear on this, is anybody who encourages this to happen or says something online in an online statement, "Yeah, we need to burn cop cars," as a general statement. Is in 5 to 20 land, and I just don't know that I don't have a problem with that being 1 to 5 felony if it's something that's a statement. I just don't know that the action of actually going and getting explosives, getting a fire, the physical act of violence and brazenness to actually set a car on fire and do this is 5 to 20 land. I completely agree with that. My concern is when we look at and aid and abet goes with that in our normal framework, but advises, encourages, counsels. There's a lot of words. Was that string of elements or options taken from somewhere it's in code, or is it did that come from?
I believe that came from code, yes.
Where did it come from specifically?
I don't know specifically, honestly, right now.
I'm just saying parenthetically to the committee, we have a criminal solicitation statute and that is stepped down for very serious crimes. A criminal solicitation for a much more serious crime could still be less than this. Or are we putting this behavior of encourages and advises?
I think we're talking in the context of gangs planning these things.
Yeah.
I think that's where that comes from.
Yeah. Okay. I just asked the question.
One thought I had on that same note, given the fine that we have, I wonder if there was some thought that it may take a 5-year probation sentence to pay that fine off. I don't know if that's one thing that may be considered when you look at the sentence that you have on this. Obviously, my understanding is that entire sentence could be probated in the event that's what a judge decided to do. Do you have any thoughts on that?
I would be fine with that.
Well, I think that's what your bill does right
Yeah.
now. The
Yeah.
way I read, unless someone wants to correct me that knows more than me. But any other questions from the committee? We do have one person signed up to speak on the bill.
Sure.
James Woodall from the Southern Center for Human Rights. Good evening.
Good evening, Mr. Chairman, members of the committee. I'll be
Good
very
to see you.
brief. And I think somebody left their iPad up here.
That would be Chairman Rod. I wonder why you're coming back again. You're not on Judiciary.
Oh, okay.
Oh, you're recording. Yeah, everything.
So I'll be very brief, Mr. Chairman, but I wanted to bring up 2 points, and it's really into this heart of the question that both Senator Cowser raised as well as Senator Sessler. So 2 concerns. One is the redundancy of this. These offenses that we're talking about, the vehicles that are being burned can already be prosecuted under the arson statute as well as criminal damage to property. And so arson in the first degree carries a 1 to 20 year sentence plus 50 years to Senator Cowser's point. 1 to 10 years for second degree plus a $25,000 fine, and then 1 to 5 plus $10,000 fine for third degree. And then criminal damage to property carries a sentence of 1 to 10 with the possibility of 20. There was a bill passed last year about critical infrastructure, and then in the second degree 1 to 5 without a penalty, a civil penalty assessed there. And then the other part I wanted to raise was around the restitution part that you raised. GACTO, I believe, brought this point up last time in committee, where insurance being more likely a means of recovery than restitution. It is true that it could be, probated and somebody's fine. I mean, you have to raise those funds, but it is not. I mean, they're insured for a reason, and so we're not trying to give explanation or apology for why this kind of behavior is happening, but just to make sure that we do know this is being prosecuted. In fact, when we remember in 2020 when individuals were burning vehicles in the Atlanta Police Department, those individuals were prosecuted to the fullest extent of the law. So this is not necessarily a needed change or modification to the statute. In fact, we have, very robust and very responsive needs. Very responsive statutes that address this behavior already.
Mr. Wall, is it different, though, when someone burns a law enforcement vehicle? I mean, the psychological side of that, what it does in the heat of a protest, what it does in a sense to society when that's done. I mean, should that be different than a typical arson?
So having actually had that experience of being at a protest where that happens, obviously I wasn't the one that burnt the vehicle.
Right. Don't make any more statements.
That's right.
Yeah. We'll have to get Cowser on you.
But I'm not going to purchase myself. But I don't believe it's different, because regardless if it's a police vehicle or if it's a personal vehicle, there's still a loss of property, right? And so the fullest extent of law being used to prosecute those actions, I think, currently exist in the law. And so, insofar as we say, this isn't a necessary bill, I mean, if you look at the bill as drafted, the sentence structure is already accounted for in both the arson and the criminal damage to property statute. Yeah. So there's not more time you're going to be spending in prison. There's not more money to Chairman. I keep saying Chairman Cowser. But Senator Cowser raised a point about the $100,000. We look at 16-7, 22, 23, 24, or 16-7, 60, 61, 62. It's already accounted for in that. Mm-hmm. And so I'm curious as to whether or not a prosecutor had to pick and choose or, stack charges. But that behavior is already accounted for in the code.
You made a point as we joked about you being in a protest, but when this happens, it affects those that are trying to express their First Amendment rights, which I do support the First Amendment, despite what I said this morning. And so you look at what it does to people that are protesting, and of course to law enforcement that's trying to protect people while expressing their First Amendment rights. And so that's the reason I bring that. I don't know what the right number is, but I just. Yeah. In my opinion, I think it should be something separate. I think it is different when that happens, what it does to everyone that's trying to express their First Amendment rights at that point. And now I've invoked more questions. Senator Setzler.
Chairman, for members of the committee, and to Representative Silcox, the language comes exactly out of the arson statute. It is word for word. So essentially what you're doing is you're copying the arson statute, all those aids, abets, advises, and you're just putting it in place again and having a minimum of 5. So that answers my question. Yep.
All right. Any further questions for Mr. Woodall? All right. Thank you. Appreciate you as always. Everyone decided to speak on the bill. What's the pleasure of the committee? Motion to pass from Dr. Watson. Do we have a second? Second from Senator Hodges, any discussion? All those in favor, and I guess I should say LC 480852. You're supposed to hit me and say that. All those in favor of the motion, please raise your hand. It is unanimous. All right. And who will be carrying the bill in the Senate? Last year it was Senator Albers. He never has any bills, so I guess he needs one to have. So we'll put him on it again. Thank you. With that, we are adjourned. Thank you.